My name is Albury Initial C, and today I appear on behalf of the defendant. The defence in this application is seeking the court to exercise its discretion pursuant to Section 130 of the Evidence Act to exclude the defendant's record of interview with police where he made admissions that are now the basis of the Crown's case. In this application, I will submit that these admissions should be considered highly unreliable and prejudicial to the accused, and that accordingly it is open for this court to exclude the evidence on either the fairness discretion or the public policy discretion. I will now discuss each of these grounds in turn. In relation to the fairness discretion, it has been held that courts should reject evidence that where the evidence in question is of little probative value and is highly prejudicial to the accused. This question is to be determined by reference to the conduct of the police and the circumstances of the matter. Considering the probative value of this evidence, it is submitted that this is a case where there was an extreme power imbalance between the accused and the arresting police officers. It is submitted that this led to such an overpowering that the admissions made by the accused are now considered totally unreliable. The reasons for this overpowering are clear. First of all, taking into the accused's personal characteristics. He is a 15-year-old Indigenous boy from Cape York. The situation of being in police custody in Brisbane without any legal representation means that during this time he was confronted with a highly intimidating and completely unfamiliar environment. This unfamiliarity and pressure on him was only added to by the overzealous conduct of the police officers. The accused was kept in police custody for 9 hours. During this time, he was detained in the back of a police vehicle, taken on a 45-minute drive to the police station, and then subjected to over 5 hours of questioning. In these circumstances, it is submitted that the great power imbalance between the accused and the arresting officers was so extreme that there is a high likelihood that the accused's admissions were only made due to the exertion of pressure upon him and his wishes to conform to the exertions of police. Turning to the prejudicial effect, it is clear that the admissions made by the accused will be highly prejudicial, as these admissions are now critical to the Crown case. Therefore, it is likely that the admissions will be central in the jury's mind in determining his guilt. Therefore, it is submitted that this is a case where admission of the record of interview would prejudice the accused unfairly, and accordingly, that this is an instance where the accused deserves the protection of the court through the rejection of the evidence. In the alternative, it is submitted that it is also open for this court to exercise its discretion to exclude the record of interview pursuant to the public policy discretion. In the case of Bunning against Cross, the High Court held that the court has a discretion to exclude evidence that was obtained in an unlawful or underhanded manner. In this case, I submit that the arresting police officers have committed 3 flagrant breaches of the Police Powers and Responsibilities Act that all make this ground open for the court to exercise its discretion. The first of these breaches was that the police failed to notify a legal service for the accused pursuant to Section 420 of the PPRA. Secondly, that by holding the accused in custody for 9 hours, the police breached the maximum detention period of 8 hours under Section 403 subsection 2 of the PPRA. And finally, that the 5-hour questioning of the accused was in excess of the 4-hour maximum questioning period prescribed by Section 403 subsection 4A of the PPRA. As this is submitted that there has been unlawful conduct on the part of the police officers, the court must now turn its attention to the 5 factors announced in Bunning and Cross to inform whether discretion should be exercised to exclude the evidence. First of all, turning to the nature of the unlawfulness. I submit that the unlawfulness here of the police officers cannot be characterised as merely an oversight. Rather, the fact that multiple breaches have occurred, all in relation to the questioning and arrest of the young boy, point to an implication the officers were acting deliberately to exert influence on the accused in order to reach an admission. Secondly, turning to the cogency or the reliability of the evidence. I did address reliability in my first submission in relation to the fairness discretion. However, I now also submit that the reliability of the admissions can only be further reduced when it is considered when the police officers detained the accused for a period longer than they were allowed to, and also questioned him for a period longer than they're allowed to, all the while the accused did not have any lawyer present. The duration of questioning, in conjunction with the already established power imbalance between the accused and the arresting officers, could only have increased the pressure on the accused to provide an admission, to the point where it is now submitted that it cannot be considered as reliable evidence. The third factor is how easily officers could have complied with the PPRA. It is submitted that there was nothing in the circumstances here preventing the police from contacting a legal aid organisation or detaining the accused for the proper time limits. Fourthly, turning to the severity of the offence. It is acknowledged that murder is the most serious offence a person can be charged with. However, it is submitted that this factor alone does not justify the admission of the record of interview when considering the flagrant breaches of the police officers. Finally, we can turn to the purpose of the PPRA. One of the clear purposes of the PPRA is to ensure that disadvantaged persons who are arrested are still treated fairly and in accordance with their rights. Clearly, the conduct of the police officers in this case is antithetical to this purpose. Based on these factors and in the circumstances of the case, where the police officers here have flagrantly breached the fundamental rights of an accused child, it is submitted that it is clear that the court should exercise its discretion under the public policy discretion to reject the evidence. Your Honour, it has been submitted that this court should reject the admission of the record of evidence of the record of interview through under either the fairness or public policy discretion. Although acknowledged that these are separate discretions, it is hoped that Your Honour has seen that in this case there is significant overlap between them. And the defence submits that in totality, the court should recognise that the defendant's record of interview obtained by the police is manifestly unreliable, highly prejudicial to the accused, and accordingly that its admission into evidence would be not in the interest of justice. Thank you.